Today I'm going to talk about what to do if you get a notice from your landlord. There are different kinds of notices, but how you respond is very similar for each. I'll start with a courtesy notice. These are usually just a polite request to do something or stop doing something. These generally have no legal significance, but can lead to that. So you should not ignore them or any notice. As with all notices, you should always respond. This is important, so I will repeat it. You should always respond to a notice from your landlord. Failure to respond can be taken as an admission, an agreement, or an acquiescence, possibly even beyond what it is in the notice. So your response should at least be in the same form as the notices. Most notices will be in writing. Landlords generally know the importance of putting any correspondence in writing. And when I say in writing, that means on a piece of paper. Email, text, smoke signals, none of these are generally considered in writing. Your response should always be in writing, and you should keep a copy. This is to protect you and so that you have an accurate record of your response. This eliminates any of the she said issues. A typical courtesy notice might say, you left a bicycle in your driveway overnight. This violates park rules. Please make sure not to leave things in your driveway overnight. A typical response might be, I do not believe or I deny that I violated any park rules and there is no bicycle in the driveway at this time. Now, note, this is both a denial and statement that the alleged violation, if it ever occurred, is no longer occurring. That last part, there's no bicycle in the driveway now. It is important to always state the alleged violation never occurred or was not a violation, and if appropriate, is not occurring now. All while being polite. Never be argumentative. Never say things like, it will never happen again, because that's an admission. Never say, it's no longer happening, because that's an admission as well. Admissions can and do have troublesome, unforeseen, and legal consequences. It is not a lie or being honest to deny an allegation. You're right in a courtroom. You get accused of something, you have the right to deny it. So, same thing, you're accused of something, deny it, because it may not be an actual violation of the rules. It may have been a rule that's been waived. There are so many things that you may not be aware of that may make it not a violation. Always deny. So this is the way you should respond to all notices. So many times tenants think, I thought I violated the rule, when in fact they were wrong. But when you admit you violated the rule, you can't deny or prove it later because you've already admitted it. So don't admit it. And don't think for a minute that your landlord won't do that. They will. And even if they don't, the next manager may. So you think the manager is your buddy and, oh, they would never do that. And next week there's a new manager. They've got a letter from you admitting some violation. So never admit anything, and don't trust that your current manager is trustable, because even if they were, they may not be there tomorrow. Back to your response to a notice. It is important to be brief, not make excuses, not try to explain, oh, well, my grandson was here and I didn't realize he left his bike. Absolutely not. No explanation, no excuses, nothing. Because they may be an admission and they just invite argument. Don't try to explain. Don't try to make excuses. Just deny. And it is important to respond right away, usually within a week. Next type of notice is what is called a curable notice. These are conditional termination notices. Many people, especially landlords, like to call these eviction notices, often putting eviction notice right at the top in big letters. These are not eviction notices. Don't panic. You are not being evicted. You will never get an eviction notice from your landlord. Only a court can evict you, and only after a court proceeding or trial where you have had the right to appear and present your side of any dispute. There's another video in this series that discusses the eviction process. I urge you to check that out. So, curable notices. This notice must be in writing to be valid, as I talked about earlier, unless your rental agreement has a separate provision about electronic notifications, and it allows some notices to be delivered via email and email only. So I would check your rental agreement just to see if there's provision for that. So back to the notice. The notice must clearly state the alleged contract, provision, rule, regulation, or law that you are alleged to have violated without citing any particular thing. It's not a valid notice. It must, too, state how it is or what it is you have done allegedly to have violated that rule or provision. 3, it must state at least one possible action you can take to cure or remedy the alleged violation. And 4, it must give a time frame in which to do so and state that if you don't, your tenant agreement may be terminated. Remember, a termination is not an eviction, despite what it may say on the notice or the landlord may say. It's just a termination notice. Again, curable notice, like all notices, you should always respond in writing. Again, you should always deny any violation, the equivalent of a not guilty plea. Even if you think you may have violated some rule, you should deny any violation because you may not have, or the rule doesn't apply to you, or the notice is not a legal notice, or so many other reasons you may be totally unaware of. Did I mention it may have been waived? Just one of the many things tenants are not familiar with, where it would mean that in fact you did not violate anything. Respond in writing, and the first thing you do is you deny any violation. Because again, any admission, you don't get to withdraw that admission later. 2, you should always deny the validity of whatever rule they claim you may have violated, because again, it may or may not be a valid enforceable rules. Lots of rules out there that are a violation of the law. They're not valid enforceable rules, and so the rule is not valid. So deny that you violated the rule, deny that the rule is valid, deny that the application of the rule applies to you. The rule may not apply because there's been a previous waiver, or there may be many reasons the rule doesn't apply to you. So deny that you violated the rule, deny that the rule that they are citing is valid, deny that the rule applies to you. 4, you need to deny the validity of the notice itself. This is not a valid notice, because if it turns out later not to be a valid notice, you may have waived that issue. That's an issue I deal with all the time. Landlords sending notices that aren't valid, and tenants admitting that they violated some rule or that rule applied to them or whatever. And in fact, the notice was not valid, but the landlord or the tenant has now admitted to violating some rule. So don't do that. Don't admit that you violated the rule, that the rule is valid. the rule applies to you, or that the notice is valid. So deny the notice is valid. You also, an important thing to do is to deny that this notice can be used for any reason at all. Future reasons for further notices. Sometimes there's rules about 3 notices. And again, if you don't deny it at the time and you wait until you get that third notice, you can't go back and deny the first notice at that point because you didn't deny it at the time. So you need to deny that the notice is valid for those reasons. And then finally, you always state as a precaution the alleged violation. Clearly, you want to say the alleged violation is not occurring now. This would be a cure without any admission. Well, even if this had happened before, alleged violation occurred, not occurring now, you've cured without admitting that you ever did anything. Never say, I stopped doing it, because that's an admission that you were doing it. So you need to be really careful about the language. Keep it short and simple. That's why I say you don't do explanation, you don't do excuses, you don't do argument. You just say, I didn't do it. Rule doesn't apply to me. Not a valid rule. Notice is not valid. You can't use this notice for future notices or anything else. You can avoid arguments or giving your landlord something to argue about, because you don't want to argue about this. Doesn't help. They've stated their position. They think you violated some rule. You have stated yours. Arguing just makes things worse. If they want to move to the next step, they will. But having denied everything, you're in the best position possibly be if they want to move to the next step. And I'll tell you, arguing with them only encourages them to want to do the next thing just so they can prove that their argument is right and yours is wrong. So don't argue. It just pushes them to be bullies. And they're just less likely to engage if you don't argue with them. And it doesn't matter how nice, how friendly they seem to be. You have to understand that their interests are the exact opposite of yours. And there are no exceptions. Don't think, well, my manager isn't like that. Yes, your manager is. And yes, your owner is. And as I said earlier, even if you think your manager, current manager, is the greatest person in the world, they may be gone tomorrow. And I'll tell you, 30 years of doing this has proved to me time and again that tenants who believe that, oh, my manager isn't like that, have always been proven wrong when it came to the pedal hitting the metal, however you say that. And the consequences of being wrong about what a nice guy your manager is can be the loss of your home. So you have nothing to lose if you assume your manager does not have your interests at heart. To believe the manager on your side is just wrong and can mean the loss of your home. There is no risk in not trusting your manager or landlord. The relationship is about money, the rent. It is a business relationship. It is in your interest to keep it that way. And don't think you can keep business and friends separate, because you can't. And I'm telling you again, 30 years of doing this have proved to me time and again that the bottom line is about money, not about friendships. And the manager that the tenants thought was the nicest guy and who never would do stuff, he either does it or the owner fires him and hires somebody else who will do it. You have nothing to lose by assuming that that very friendly, nice manager does not have your interests in mind. Finally, we get to the non-curable notice. These have some of the same requirements as a curable notice, except they're non-curable which means there is no cure, and termination may occur per the notice. The notice must, one, clearly state the alleged contract provision, rule, or regulation law that you are alleged to have violated, and it must state how you have allegedly violated the rule. Your response is the same. You should always deny the violation. It's the equivalent of a not guilty plea. And even if you think you may have violated some rule, you should deny any violation because you may not have, or the rule doesn't apply to you, or the notice is not legal, or the previous notice relied on was not legal or valid, or for many, many reasons you may be totally unaware of. Generally, once you admit something, you can't withdraw that. And again, 30 years of experience doing this, I find tenants, well, but it was just one time and it was just my grandson's bicycle in the driveway. And it's like, well, two more times and you get a non-curable termination notice. So you don't want to risk that. You want to deny it. A non-curable notice might be a 24-hour termination notice for outrageous acts. These might include manufacture, delivery, or possession of controlled substances, prostitution, or your pet threatened or caused serious harms or similar acts. I urge you, if you're in that situation, look at OS 90.396 for a list of what constitutes outrageous acts. And again, deny, deny, deny. And in the case of a 24-hour notice, you need to get that denial to your landlord within that 24-hour period. A non-curable notice might also be for a repeat violation. One of the many reasons that you always deny any and all alleged violations at the time they were made and reject further reliance on them. I didn't do it. Rule's not valid. Rule doesn't apply to me. And this notice is invalid and you can't rely on it for future notices. This is why you do that part, because you can get a non-curable notice for a repeat violation. Remember, no arguing, no detailing facts, just deny, deny, deny. Finally, the risk of having to deal with an eviction is highly likely with non-curable notices. If you get a non-curable notice, you need to contact an attorney right away. That means you start the day you get it. Finding a knowledgeable attorney to represent you in these matters is difficult and may take time. Seek help right away. I get too many calls a week or 2 days before a scheduled trial asking for my help. It's often too late by then. I hear, oh, I've been busy. I didn't think it would get this far. Or my friend, the manager, said, don't worry, nothing will happen. It is often not up to the manager. That's why, again, you can't rely on your friend, the manager. The bottom line is you always need to respond and deny any and all notices. When you get a third notice for a repeat violation, unless you have denied the first two at the time that they were given, you don't get a second chance to deny those. Without a denial at the time, they are presumed to be valid. It can be difficult or impossible to overcome that presumption because you failed to deny them at the time. If you deny them at the time they were given, there is no presumption that they're valid. Landlord has to prove in court that all three notices were valid, not the third one, or not just the third one. So again, deny, deny, deny. My last comment here. Always communicate with the manager, landlord in writing. Never argue with your landlord. Don't give factual, detailed explanations. And in fact, you have no obligation to explain anything. The more you say You may have heard this on the cop shows on TV. The more you say, it can be used against you in court of law. So I urge you to keep a record, a notebook with every contact with your landlord or agents of your landlord, which might be the maintenance supervisor, the handyman, whoever. Keep a record in this notebook of all your contacts, and particularly verbal ones, because they're not written. There's no other record. So your landlord shows up one day at your door, knocks on your door, and wants to talk to you about something. Note, landlord showed up at my door, did not give a 72-hour notice prior to showing up. Landlord said this and this. I told him, thank you, goodbye. Write that in that notebook. You may never need to know that. If you ever do and you don't have it, you're out of luck. There's a legal term for that. It's called SOL. So keep that notebook. Keep it by your door, keep it by the phone, wherever it's convenient. Just write down every contact and just date, time, what was said, what they said to you, what you said to them. Don't argue. Particularly, landlord is walking by and he thinks your lawn needs to be mowed. He comes up to your door, knocks on your door, says, hey, you need to mow your lawn. So first of all, that's illegal. Landlord can't come knock on your door without a 24-hour notice. And you don't want to, you mowed it a week ago and you mow it every 2 weeks. And, landlord says, I think you should mow your lawn. Don't argue. Don't just say, okay, thank you. Have a good day. Write down what was said in your book and you're golden. So anyway, I think that is everything that I have to say on this subject of notices. Thank you for listening and good luck.